Hey everybody, Zach Wolfe here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 peculiar things about Texas litigation. If you're not from Texas, but you've ever encountered a lawsuit in Texas, you probably know we do things a little differently here in the Lone Star State. I'm here at the Collin County Courthouse this morning in McKinney, Texas. So I've got sort of peculiar Texas things on my mind. Number 5 is a little thing we call special exceptions. That was the reason I was here at the Collin County Courthouse, arguing in response to some special exceptions. What are those? They're kind of like what they call a motion for more definite statement under the federal rules, but not exactly. It's usually asking the plaintiff to replead the claims to be more specific. It's kind of a peculiar little holdover from the old days when courts were maybe a little more nitpicky about the way that you stated things in a pleading. The number 4 peculiar thing about Texas litigation is that you don't always have a clear deadline for filing a response to a motion in the trial court. So when I'm working with out-of-state counsel and a motion is filed, a lot of times they'll ask me, well, when's our response due? And I'll say, well, we're not necessarily required to file a response, and there's no specific deadline. Now, there are specific deadlines for some kind of responses. Summary judgment, motion to transfer venue, a special appearance to object to jurisdiction. Those things have some specific deadlines, but for the most part, Texas courts don't have specific rules governing when you file a response to a motion, and even if you're required to file a response at all. Number 5 is the central docket. Now, here in Collin County, they do not have a central docket, but there are a couple counties that have a central docket. In particular, I'm familiar with Travis County, that's Austin. Bexar County, the last time I was there, had a central docket, that's San Antonio. What do I mean by a central docket? What that means is that your case is not actually assigned to a particular district court. So if you file a motion and set it for a hearing, you don't know who your judge is going to be until the day of that hearing, when you'll get assigned to an available judge. The same thing is true about your trial. You will not know who your trial court judge is for your trial until the day of trial. That causes some interesting issues, and it's something that non-Texas lawyers sometimes have a hard time believing, but we do have a central docket in some Texas counties, and that is a little peculiar. The number 2 thing that's peculiar about Texas litigation is that we don't have the equivalent of Federal Rule 12b-6. That's the rule that allows a defendant to file a motion to dismiss at the beginning of a case that basically says you haven't even pled a sufficient basis for a legal claim against the defendant. Traditionally, we have not had any procedure like that in Texas. Now, that is changing because we now have a rule that does allow a motion to dismiss at the beginning of a case, but that rule has been limited in its application. You don't see a lot of motions under that rule. It's intended a little more, I think, for truly frivolous cases, but it will be interesting to see if Texas lawyers start using that rule more to the point where it becomes more of an equivalent of Federal Rule 12b-6. Oh, and also we have something called a TCPA, motion to dismiss, but let's not get into that right now. And finally, the number 1 peculiar thing about Texas litigation This is a little bit of inside baseball, but Texas freely allows amendment of pleadings without leave of court, usually up to even 7 days before trial. That's a pretty significant difference with the federal rules and the rules of a lot of other states, where usually you might get one chance to amend without leave of court, but after that, you've got to ask permission from the judge. And even though Texas is a pretty defendant-friendly state in some ways, this right to freely amend is a pretty big advantage for plaintiffs because you don't get locked in to a particular theory of the case from the very beginning. So this can be a big advantage, and the defendant is also allowed to freely amend its answer. So the defendant can take advantage of this peculiarity of Texas practice as well. So those are the top 5 peculiar things about Texas litigation. There are a lot more, believe me. I could have picked 5 other things. If you have any ideas of things you think are peculiar about Texas litigation that we could add to this, let me know. And if you like this video, hey, hit the like button, comment, or even better, share this video with someone you know. And hey, thanks for watching.